Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small, late, actually criminal law firm in central Minnesota. What's up this morning, y'all? We are here for the charging conference of Karen Reed. That's right. That's what we're talking about. I wasn't 100% sure I was going to stream today because I don't feel great. And I have a doctor's appointment a little bit later, but I was watching Bev Canoni murder justice live and I just couldn't not stream anymore. I got so mad. I put on my America tie. That's right. Look at this guy. Look at this tie. What? How can we not have freedom in this country when we have this? That's right. That's right. This suit coat is going to end really soon. I'm fucking dying. It's so warm. But we stand on principle. We sit on principle in front of a camera and a microphone, and we're going to be screaming about this in just a second. I'm going to start the day over on the video. Something I don't normally do, but I don't know that we're going to get through, like, I don't know that Bev is going to go all the way through the day. It doesn't look like their charging conference is going to take that long. And I think the really important stuff is happening early. Joshua Anofsky says, you missed so much amazing stuff yesterday. I know, I'm sorry. I had to go to the doctor, and yeah, I have an appointment later in the day to talk about some test results and stuff that are hopefully done. But I'll keep you guys posted as that becomes appropriate. For now, just know that I was at the doctor yesterday and trying to resolve a lingering issue. So we'll just see how that goes. Doesn't really matter all that much in the end. Let's see. Trying to get this super tip window in the right place. Did you get the butthole aids? No. Nothing like that. Okay. Let me get my chronic lymphocytes leukemia. No, I don't think so. I don't think I have cancer or anything. Don't worry about that. Holy shit. Stop it. You're scaring me. Just kidding. No, I don't think I'm dying. Or anything. I'm just getting my windows. I'm getting my chat windows set up. And then we'll get moving here. Hope you guys are doing well this morning. Nose aids. No. Wisdom teeth pulled. No, I already got those pulled. I have no wisdom left. I lost that a long time ago. I woke up during my wisdom tooth surgery. That was fun. Cool thing about narcolepsy is you could just go back to sleep when stuff like that happens. But I woke up and I heard like a crunching sound, and I opened my eyes and I looked into the eyes of my friend. My friend was my oral surgeon. And I looked into the eyes of my friend, and he's sitting there like doing something horrifying. And I was like, you know what? Fuck this. And went right back to sleep. So I'm not going to stick around. This is horrible. Let me get rid of these windows. Gosh, a whole bunch of annoying stuff. Pulled up. Okay. All right. I think we're about ready to go. You had to be awake for yours? Tati Feyre, again, I put on this tie. I know Branca takes off his tie. He doesn't take off his tie when he's pissed. He takes off his tie when he's drinking. That's different and also very, very funny. But I didn't put on this tie because I've been drinking. No, I put on this suit and I put on the jacket just because of the tie. But again, we have a freedom tie, a justice tie, a liberty tie, all of the good things. It's America, baby. Let me get some good old fashioned sweet tea in my cup, and then we're gonna do this. Oh my gosh. Okay. That being said, hello. Sweet tea is gross. What's wrong with you? You're gross. I have a half mind to ban you for that kind of bullshit. What are you talking about? Weird way to say a mixed drink, but whatever. I can't have mixed drinks, man. It's not even like a joke. If I do any of that stuff, I go to prison. And I'm dainty. I don't want to go to prison. I don't want to do that. Speaking of which, let me see if I have to test today. All this background noise. Okay. I really need, I need a app that does the stupid call in for the testing for me and just texts me whether I need to go test that day. Do not test today. I've had to test randomly twice since my probation started. My probation started almost 60 days ago. It's really, really light. Lou S. Haven't heard in a while, but any updates on that studio you were building? I was never building a studio. I want to, but that's not going to happen for a really long time. My life was kind of disrupted for a bit. So, okay. All right. Let's get Canoni pulled up here. Well, these are the Higgins texts. So I'm sorry if you guys have already been watching this morning. Like I said, we're going to go back. Whoa, judge sentences woman for having sexual relationship with high school student. What possesses, it seems more common amongst female teachers. Does it seem like that to you? Am I crazy? Well, the relationship thing. I think with the male teachers, it's usually just called a sexual assault of some sort. And with I think they're just deferential to female teachers, and what should be labeled a sexual assault, in my opinion, gets labeled as a relationship. But that's just me. That's just how I see things. It doesn't really matter. Okay, let's I haven't looked into it. I could be way wrong on that. Okay, go away. Man, I wish I could. Okay. Here we go. Steve Moore says, driving without interlock device, got supervised probation for a year, but saw PO 3 times, lucked out big time. Let's go, FKR. Yeah, I only have to see my Excuse me. I only have to see my PO 4 times a year. It's all very weird. It's like, this doesn't seem like, I know that probation catches a whole bunch of people. So thank you, Island. I'm in my angry clothes today. Here's Beth Canoli or Canoni or whatever.
Was now open. You may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Laura McLaughlin. Good morning, Ms. McLaughlin.
McLaughlin.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Velez.
Sorry, McLaughlin, don't wear that. Don't wear what are you doing? Why are you wearing a yellow jacket? It's fucking sunrise in the courtroom. You're a big girl. Like, don't wear a yellow jacket in a courtroom year round. Why would you set yourself up like this? No. Alessi, yell at her, please. Just do it.
Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Ron. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right.
Jackson and
So,
Little are out today. This
first-
makes sense. Jackson and Little are they're back at the hotel or whatever. They're prepping their closing argument. They're not sitting around at this waste of time charging conference. Alessi and Yannetti obviously clearly capable of handling any argument that's going to happen there. So Jackson and Little will be prepping all day. Violently.
First thing we left off yesterday was whether KKKK for identification, the PowerPoint of
We moved it
Dr.
to
Rentschler would be
4Ks.
entered into
I
evidence.
really hate black people.
It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the party finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument.
Yeah, so there was no rebuttal case put forward by the state. That is either a bold move or a baller move. I don't think it's either, really. We're about to get to this argument about why the court should have a directed verdict of not guilty. And Yannetti is going to very eloquently explain how the Commonwealth just simply did not put forth evidence, and there is sufficient evidence admitted into the record to raise an obvious level of reasonable doubt that the Commonwealth did not surpass its burden. And he's right. He's 100% right. There's no way around it. The Commonwealth did not meet his burden. The Commonwealth did not show. They did not present evidence that car struck John O'Keefe. They didn't. They did not do it. It's amazing when you go back and look through listen through the witness testimony and pay attention to what was actually said. They did not provide any evidence that the car actually struck him at all. The accident reconstructionists couldn't even put down a credible accusation that the car was the cause of any injuries on John O'Keefe. There's one guy who's like, well, I put paint on my arm.
Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you.
That's what he's
We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was
Hey, you know what's great is I haven't actually watched all of this. I've only watched the last minute of Yannetti's thing, and I was spot on where the argument was going. And it's true. It's true. It's so fucking obvious. It pisses me off because so I'm going to say it. I'm going to say it right now because I'm mad about this. Everybody, every time we do one of these trial watches, every time someone's like, people are like, oh my gosh, I can't believe this trial is like this. Every trial is like this. All of them. The notion of justice and fair play from the state against defendants in this country is dead. It's dead. It's buried in the ground. It doesn't belong in the land of the living. If it did, it would be rotting and it would be saying brains, trying to kill and eat everybody it could find. Justice is gone for defendants in this country. The few that happen to win by skipping into luck, not into normality. Normality and normalcy would have defendants actually being acquitted on the daily. It would not have plea deals be the preferred method of self-defense from the state. It would have going to trial being the reasonable option, the one you're guaranteed in the goddamn Constitution. That would be the one that people would want to do, because that should be the avenue to mount and present a proper defense, knowing that you might have a chance of getting off. But as you watch the state truncate and annihilate and remove the ability for the defense to even argue for its own innocence, watch it here, but know that it happens in every single goddamn court, in every single county, in every district in this country. All of them, every judge, every single state prosecutor acts like this. This is not unique. Every time we watch these trials, everybody's like, oh, I can't believe this prosecutor. Every single one of them, without fail, acts like this. There is no exception. There is no good prosecutor. There is no good judge. You might catch them on a day when they're sleeping, and that's when you get acquitted. You don't get justice in our system. It's all a fiction. It was written down and never honored. And I'm so tired of pretending like we have it. Watch it get eroded in every case that you watch online. Every single one. You're always asking the same questions. How can the state do this? How can the state act like this? How can the state do this? How can the state do this? The problem is there's a bunch of assholes who are obviously guilty. Hello, me. Like that. Obviously guilty. But there's a bunch of people who are not guilty, and they don't even have a chance at justice. And there's a bunch of people who are really, really guilty, but the state did a really fucking bad job of showing it. And they should be acquitted too, because the state should be held to a standard, because every bad guy that doesn't get acquitted when the state screws up, every time that happens, it erodes the possibility that the good guy who was not guilty will have a chance at being not guilty. And instead, they will trade away their own liberty, because the alternative is somehow even worse. They will go to prison for months and or years to avoid the effective life sentence that they would otherwise be threatened with by the state and be very ripe for receiving. And no one will care. No one will care, because they're not an attractive woman. They're not a wealthy person. They're not a celebrity. Their case isn't sexy. They have a bad set of facts. And a lot of times, they might be guilty. People are very uncomfortable with letting guilty people go. I'm not. But this happens every day. Every day. And as we continue to watch trials, I'll show you that every prosecutor acts the same.
not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened.
We have a couple super tips that came in.
Mama say, mama sa, mama kusa, mama say, mama sa, mama micropene. Mama say mama sa. Muma kusa. Mama say mama sa. My micropene. Oh snap. I meant Kurt's micropene. Nick, delete this or I'll.
Are you what? That came in yesterday in the middle of nothing. I don't know what they'll do. I don't know what they'll do. Girl Friday says, I'd rather 100 guilty people go free than one innocent person go to prison. A very famous quote, or a very famous notion, I should say. I don't think that's the exact quote. How dare you? But so few people in this country actually believe it. And it's getting scary. It's getting very, very scary. Again, my demons and my mistakes are my own. I made them. I made the choices. I own them, right? Like those are my problems that I had. But every time I hear something like that or someone say it, I go, no one believes this anymore. I don't know if they ever did.
Hey, Nick, can I get a prayer for my dog, Allie? An 8-year-old pit bull. She goes for surgery to get a mast cell tumor removed on Monday, and we're hoping we caught it early enough. Thanks again.
Yeah, to anonymous, because I don't know who you are, but may God bless and keep your dog and your family. Hold them tight together. May the vet who's performing the surgery have steady hands and sharp eyes. May they clear out any of the mass that's there and bring your little family member, this lovable little pit bull, little murder ball, who I, jokes aside, know is a very important part of what you have. May they bring them back into health and for many more years to come. Amen, or whatever.
Not only did they not prove it struck, Hank argued yesterday against the reconstruction evidence, stating it wasn't proven how or if O'Keefe was hit, said it was unreliable. Absolutely insane.
A little bit later, and what the Yannetti thing got me a little fired up, and as I was getting dressed, I almost lost my mind in my house. When Bev prevents them from talking about evidence and the defense is sitting there saying, we requested to have an expert, the insufficiency of the investigation. She's like, you can't have anyone talk about, or you can't talk about the insufficiency of the investigation in your closing argument because no evidence was presented at trial. I almost exploded. Like I have a little light that, come on, there we go. Oh, that one. I almost exploded in my bathroom. I was like, ah! Are you kidding me? She's like, no, sorry, there's no evidence of an improper investigation or an insufficient investigation being done. And the defense is like, we asked. You could just hear you bitch after every word.
Early angry Ricada, let's fucking go. Preach, brother. Repeat it for those in the back. Reach deep into that nick down in your soul.
That nick. Miscellaneous, welcome to paralegal status. Thank you. Hey, Miscellaneous, thank you for sharing my Karen Reed song on Twitter. Made me really happy to see that go out and to see people enjoying it. So thanks for that. I will be, I just have to figure out the best way to do it, but I am going to put together MP3s of the songs. This is the main song we've made so far, but I'll put MP3s of the two versions that are up and I'll make those available. I'll just put them up on Locals or maybe make a community post on YouTube when I have them available for everybody. So I'm not trying to hide the ball from anybody on those those songs. I want them out there for anybody who wants them. I'm just going to get them into MP3 format. Maybe I'll just upload them to locals, like not like a thing, but you know, just for whoever wants to grab them. Okay, here we go. Back to this.
Such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell
Absolutely.
testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 29th when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog.
There's a problem that Bev's going to disallow this. I'm just stop spoiling it.
Which was absent from the home.
I'll just get mad when it happens.
When the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Custodial, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scordi-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here.
Yep.
But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible
Dr.
that the 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs
Good morning, Rita.
or lower body. The SUV did not hit him. John O'Keefe was
I did not hit
by
him.
the SUV. The
Oh,
case
hi,
is
Mark.
over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January.
Lagging says, are you going to catch up with what was missed? Just checking before I watch someone else's stream over the weekend. Yeah, we're back earlier in the day right now. We are catching up. This is Janetti's argument for a judicial finding that there's no possible way that a guilty verdict can be found based on the evidence presented in court, which is a correct motion, but it will be, of course, denied. Spoiler alert. that being said, his arguments here are spot on. I mean, there are rare, like, this is a rare thing. There is no dispute. The state didn't create the dispute that's required to keep this case going. The facts don't support their theory, which immediately spells reasonable doubt.
January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response. The same Brian Higgins whom
Bruno Alex says, was that jacket used by Bonnie during one of her spray and pray events? What's with all those stains? There aren't stains on the jacket. It's got this weird camo pattern. It's not a business jacket, but it's black and it matches my angry tie that I'm wearing today. My justice tie, my liberty tie that I got at Goodwill for $4.
Karen had given her back to all night. The same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video. The same Brian Alberts who is on video.
That was worded weird, wasn't it? Ooh.
Well, and received no response. The same Brian Higgins whom Karen had given her back to all night.
Go,
the same
Brian.
Brian Higgins who had to be restrained at the end of the night by Chris Albert on video. The same Brian Alberts who is on video, hot, angry.
What?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed.
Cash me out.
And finally,
How about that?
Brian Laughlin,
Fun
plowing
guy.
Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Laughlin confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
People keep asking why the suit. The suit was mainly for that rant. I'm so pissed. I'm so angry. Like, I'm so mad at how justice in this country is supposed to work versus how it does. And so I wore a suit for it. That's how frustrated I was.
Nick wasn't here yesterday and looks jet lagged. Judge Bev looks like she got her cannoli stuffed all night. Coincidence? I think not.
Gross. I hate everything about that. No. I was not on a plane yesterday. I did not do it.
Y'all see that sandwich Nick has? You see that oozing cheese? I told you Nick has been fantasizing about Auntie Beth's gooey goods. Good luck finishing that sandwich, fat fuck. Do this for you.
I hate you. Text vet. What did I do to you? How did I hurt you to deserve this? That sandwich is good. No, Lady Raggets, I asked her to make me a sandwich and she said, what kind of cheese do you want? I was like, Havarti cheese. She's like, okay. Then my light just went out of batteries again. Damn it. I'll let it charge a bit. Havarti cheese. And I'm like, all right. And she goes, well, we have Havarti and we have Havarti with jalapeno. And I was like, I don't want that. Oh, wait, I do. I do want Havarti with jalapeno. It's delicious. All right. So Yannetti just made the argument again, and this is a special motion that the Commonwealth has available. They have similar motions in all 50 states, and it's that, look, evidence is closed. Nothing else is coming in. The state hasn't made a sufficient case, or in this case, even if the state had made a sufficient case at the close of their case in chief, now that the defense has gone, we've obliterated objectively any possible notion that this could be beyond any reasonable doubt. It cannot meet the standard. The case that they presented cannot meet the standard. And again, find me the state witness who conclusively testified reasonably, either through eyewitness testimony or through expert reconstruction, that John O'Keefe was hit by a car. And that's a critical element to all three. Like, all three of the charged crimes require him to be struck by a car. Even the fleeing the scene, obviously. Fleeing the scene needs to be, you have to strike someone with the car or strike their car or whatever and cause injury with a motor vehicle to then flee the scene of an injury caused by a motor vehicle. So all of these have to happen or have to have contact with the SUV. And there's no evidence. The state has provided no evidence. The closest evidence they got is their one expert putting blue paint on his arm, saying that maybe some wounds could be caused by like a scrapey taillight situation on an SUV. That's the closest they got to an opinion that John O'Keefe was actually hit by an automobile. Grouchy old user says, but Rackets, a drunk, hysterical, clinically insane woman said she hit him after she saw her boyfriend lying dead in the snow. Yeah, exactly. That's the entirety of their case. Well, she said it, though. Woo! How lucky am I? What? That's okay. Looks good to me. I now have fried eggs. Oh, yeah. Hold on. 1 second, guys. I have to. My fingers work. Here you go. Thank you. Go pay her with a kiss. I prepaid in kisses this morning before asking for food. So. No, not a new nanny. It's just Lady Rackets. How dare you?
Hank Brennan is a little pissy baby, and that is an official medical diagnosis.
Strike that from the record, Madam Court Reporter. Hank Brennan's pisser is not little and is actually perfect for filling my cannoli. The big ones hurt.
Got rid of that sandwich because of the super dip. No, I still have the sandwich. By the way, my beautiful dark twisted faggotry has the probably best YouTube name I've ever seen. All right, back to this. We're going to hear Lally now offer the counter argument. I don't think Brennan is there. I think Brennan is working on his closing argument. Or maybe he is there. Wait, is he there? Did he show up earlier? I can't remember.
Thank you, Your Honor. Commonwealth.
But if he is, he's probably working in court. Angel sent 5 gift memberships. Thank you, Angel. Really appreciate that. Thank you so much.
Request that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied.
He's there working on argument in court.
The state of the evidence is not
Doesn't trust
dramatically
Lally.
changed since the Commonwealth rested its case in chief. Counsel makes reference.
So he just said something there. The state of the evidence has not dramatically changed since the Commonwealth rested its case in chief. I agree 100%. That's true. Here's the problem. That's because the Commonwealth's case was so thin. There doesn't need to be a dramatic change. It was so weak that all you needed was the slightest bit of pushback to change the entire outcome of the case. They didn't need a dramatic change because there wasn't a dramatic inclusion of evidence by the Commonwealth at all. Again, we don't have any of their experts or eyewitnesses testifying that she hit him with the car. They don't have anything from it other than her maybe like her potentially inquisitively or quizzically saying I hit him, like in disbelief or in questions or trying to figure out what's going on. That's the closest thing that they have to her hitting him with the car, which is insane to think about, that that's all they could muster. But he's right. It hasn't dramatically changed, but it never needed to.
To dog or canine, I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence
Listen
of a
to this.
dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog.
How fucking sinister is that argument? They had an expert there to testify about the presence of a dog in the dog bite. And the state, the Commonwealth itself, prevented them from introducing testimony about the dog bite in the presence of the Albert's dog. To then stand there unironically and without a hint of hesitation, remorse, or shame to claim that there's no evidence, not even a scintilla of a dog or the absence of a dog, when they prevented Karen Reed from arguing it, from presenting testimony about it. And they knew there's no surprise, there's no ambush or gotcha, because they knew from the first trial that the dog would come in. So they prevented it through the willing collusion of Bev Canoni. It's disgusting how the state has behaved here. And to stand there and make this argument, this guy should turn in his license.
There. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring.
It actually isn't consistent, and they had direct eyewitness testimony say, or the defense had direct eyewitness testimony say, no, that's not how it looked when it came in. And they actually showed video evidence. They showed video evidence with still frames that showed that light did not look like the state claims it looked when it was brought to the police station. But who cares? Somehow the jacket makes your shoulders even smaller.
Camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. LaPosada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness.
No. Nope. You don't get to do that shit. That guy drove by and didn't see a body. Period. Bodies become endothermic the moment the heart stops beating. which means they start losing temperature. They start taking in energy rather than putting it out, which means the body temperature will start to decrease and normalize. A 98-degree body will cool down at a rather rapid rate to get to room temperature. Just because it's not out in the cold doesn't mean that it's not cooling. It would start to cool immediately the moment the heart stopped. John O'Keefe, by all accounts, died very shortly after, no matter what theory of the case you use, very shortly after when Karen Reed left, which was early in the night. His body temperature was going to decrease no matter where he was and no matter where he, or what happened to him. The only thing that would maybe increase his body temperature is lighting him on fire like he was Chandler Halderson's mom or something, but he's not. I think. I'm pretty sure. I don't think he had lady parts. That being said, bodies start to cool right away. Heck, all you have to do is get sick with certain illnesses and your body temperature will drop dramatically, fairly quickly. You don't have to be in a cold environment for it to happen. A room temperature environment is freezing cold for a body or for a living human. The only thing that keeps us alive is the fact that we have an internal combustion engine that is sitting there chomping calories down and putting out sufficient heat to keep the body temperature where it needs to be. An 80-degree room will kill you if your body cannot produce the heat required to keep you at 98.6. Like you'll die quickly if your body stops producing heat. Now, again, as long as your heart is pumping, it's really hard for your body to not produce heat. But this idea that a body's going to sit there and stay warm is like, well, it's like inside there's no snow. So what? And the clothes on this person aren't insulating heat. He's not radiating heat. He is not exothermic. There's nothing to trap between the fabric to maintain a layer of heat between the heated air between the fabric and the body. There's nothing coming off the body that the fabric is holding in next to it. So it's not keeping this layer of warmed up air that would normally be there. It's very frustrating. Very, very frustrating that they're trying to use just sort of they're trying to use a lack of knowledge of biology, anatomy, physiology, physics, that common people, they don't need to know the details of how all this works. You just go to work or whatever. Like you go to work, you raise your kids, etc. They don't need to know all this, so they're relying on a common ignorance to try and push this case. It's really disgusting. I hate the Commonwealth in this case.
Who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well.
Oh,
and as the court could see
backing into a basketball hoop doesn't mean that you
video drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There's been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, I have to do this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
So Bev just says, I have to do this in the light most favorable to the Commonwealth. Because the Commonwealth is not the moving party, the motion must be read in the light most favorable to the non-moving party. That's a standard of motion practice. Notice that Karen Reed didn't get that on any of the Commonwealth's motions, but let's just ignore that for a minute and talk about this. In the light most favorable to the Commonwealth, you have to generate evidence that they didn't put on the record for this to work. not view the evidence in the light most favorable to the Commonwealth. You have to create evidence that the Commonwealth failed to make, failed to present, failed to show, failed to get expert testimony on, failed in every single way. That's the only way you get to the conclusion that Bev just got. You say, oh, I have to review it in the light most favorable to the Commonwealth. Yes, you do. We all know that. But the problem is there is no evidence. There is no argument that is favorable enough to the Commonwealth to overcome the fact that they just didn't put it on the record. And if you didn't put it on the record, how do you have a case? You don't. You don't. So it's denied. Not surprising. I mean, if nothing else, ignore the reality of the motion, the legal argument. Ignore all of that and just go with the basic politics of this case is huge. This case is public. The idea of a directed verdict from the judge is almost impossible. There's just no way she's going to do it. It's not going to happen. And this is a problem because those considerations should be absolutely irrelevant to the question of whether or not the Commonwealth put forth a sufficient case to take away someone's liberty for potentially the rest of their lives. She has MS. She'll likely die in prison. If nothing else, part of fighting MS requires a higher level of activity and, consistent monitoring of your physical health and your excuse me, your physical wellness along with your health and your mental wellness. Like you have to be mentally strong. You have to be physically active to fight MS. Prison isn't a place to fight MS. Karen Read will likely, no matter what the sentence is, die in prison, or she'll get to a point where she's incapacitated and invalid and be released from prison at that point, in which her life will be, severely truncated until she dies. That's her reality. Her reality is not like, oh, I'll be out in 4 years and I can go on with my life. She will deteriorate rapidly under those circumstances. The celebrity of the case, the publicity of the case, the severity of the charges, even. None of that should be a consideration in a motion that says the Commonwealth, who has all of the burden in this case, did not sufficiently raise evidence to meet the basic elements of the crimes that my client is charged with. The consideration of that motion should be entirely devoid of these outside considerations, and they're made every single time. Even if cases aren't big cases like this, the severity of the charges will become a deciding factor for the judge. And they may not say it, but they are, oh, I can't let a murder victim go. It's got to go to jury. It doesn't have to go to jury. That's another thing. There's always this notion of fairness. Oh, there needs to be fairness. No, there doesn't. There doesn't need to be fairness. Fairness is the minimum bar. The minimum bar. The minimum bar is fairness for the defendant, and that's a jury trial. But a dismissal from a judge, you have a right to a jury trial as the bottom rung. The bottom rung of liberty is the right to a jury trial. A judge dismissing your case because it's ludicrous isn't a problem. In fact, it's a solution. You don't need to exercise the right if the right is obviated by the facts and the status of the law. The status of the law says you don't have a sufficient basis to bring these charges. They should be dismissed.
Okay. All right. So regarding the charge,
What's up, Ava? How you doing?
so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw two of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness.
Someone asked if my cup was a Star Trek cup earlier. Yeah, well, it's double themed. It's a Father's Day cup that I got, and it's got me with all my kids and little Sonny. Well, wait, no, this is sorry. Yeah, little Sonny down here, little pug dog. So, yes, Star Trek plus Father's Day.
Witness argument and request for instruction. You're withdrawing that?
With regard to
Drawing?
witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right. Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time.
Also, I am Your
Who's arguing
Honor.
for the Commonwealth? Okay, so
I just want to let you yell at
Sort
everybody.
of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking an instruction on for the Commonwealth.
All right, so we will deal with that. I'm going to go through the
Didn't quite hear what he said.
defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you requested.
We're gonna get to
so
that argument
I will
anyways.
probably-
I'm not gonna go back.
Okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear. Okay? So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction? Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give.
Scooter McJuder, I don't want
I will
people.
give you Bowden.
I'm hiding.
I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay.
Let me look up what a
Go
Bowden.
ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, I would.
Oh wait, this is really fucking infuriating. Steel yourselves, my friends. You're about to witness injustice.
Incorporates, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So, I
Okay. In Massachusetts, a Bowden instruction is a jury instruction that allows jurors to consider the failure of police to conduct certain investigations or tests as evidence, even if those failures were not explicitly part of the standard evidence presented at trial. This instruction essentially permits jurors to draw an adverse inference against the prosecution due to the police's omissions, suggesting that the omissions may have affected the reliability of the evidence or the thoroughness of the investigation. There is easily sufficient evidence for a Bowden instruction because blood was collected in fucking red Solo cups. There's nothing else you need to do. There is nothing else you should need to say. You should just hold up a red Solo cup and be like, Judge, really? 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 Hey, really? Right? Like, that's it. That's it. There's nothing else. The insufficiency of a red Solo cup in the preservation of DNA evidence is obvious on its face. It's ridiculous to people of common understanding. And there is no amount of curative fake testimony that says, oh, well, you kind of go with what you have. No, you don't go with what you have. And why is all you have red Solo cups? You're investigating a crime that involves the death of someone. Why don't you have any proper way to collect blood samples from snow? Why on earth is this it? You're a mile and a half away from the station. Go get some. Uber Eats yourself something better. Like, bring any way to get any other container to that scene. And they didn't. They didn't do it. So they obviously should have a Bowden instruction that's general, and they should have one that's particular. Let's see how this argument goes, though.
Would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like.
This is a lie. And it's a disgusting lie. One, because there were questions asked by the defense. Yes, there were questions about the sufficiency of using red Solo cups. And there was testimony that that was not an ideal way to collect DNA evidence. That alone is sufficient for the Bowden instruction. That alone is it. Even though there was testimony that sometimes you use what you have, the testimony was that red Solo cups are not the ideal way to do this. So now you have a Bowden instruction, period. There's no argument. But what he's about to argue is even worse, because the defense tried to bring in an expert on investigations specifically to talk about the insufficiency of the investigation. And the Commonwealth motioned to keep that evidence from being entered into court, and Bev agreed. And so he's going to testify that they didn't bring in anybody to, or he's going to say they didn't bring in anybody to show that this investigation was not properly conducted. Disgusting, 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 disgusting. May they burn in hell for having this approach.
So in the instruction and the arguments are based or predicated based on evidence. Not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a Bowden or third-party instruction, but specifically for even counsel to make that argument during the course of.
And it's a lie. You're lying right now. God, I hate you. Oh, you're just lying. Because your witnesses had to admit that it wasn't sufficient, that it wasn't good enough, and they did it. There was elicited testimony. Yes, the questions raised the question, but your idiots gave the answer. Oh, I'm angry.
And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials of packaged evidence, chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrificed.
I'm really pissed off that Yannetti was not prepared for this with a red Solo cup. That's all he had to do. Judge, come on. That's it. That's all he had to do. Pull up a red Solo cup. He doesn't need to sit there talking like a dummy. No, just pull out a red Solo cup and say, Judge, what are we doing here? What is this? Were you serious? Are you serious? Are you serious? Imagine this is a paternity case, right? Imagine, take away the criminality, take away the state. This is a paternity case. And one party brings a red Solo cup full of semen and says, ha ha, we got him on the paternity test right here. Like a man, or no, look, here's a red Solo cup full of my spooge. And it says I'm not the father, like on Maury or whatever. Imagine that. And imagine the judge going, I'll allow it. Insane. An insane proposition. But the state does it and it's fine. It's obviously inadequate. It's obviously insufficient. And the fact that Yannetti is not there just pulling out a red Solo cup going, Judge, what are we doing here? What are we doing here? What are you asking the people of the Commonwealth of Massachusetts to do when they consider this trial? You're going to say that this meets the evidentiary standard of of this Regal courtroom. You're going to say that this is sufficient, that this isn't an outright and flagrant violation of someone's rights? You're not going to give us a Bowden instruction? You're asking me to justify a Bowden instruction in the face of a red Solo cup? Why doesn't he have one? People have criticized me for not having one. Why doesn't Yannetti have one?
Because he's a Boston cop too. There was just a focus on Ms. Reed.
It was 6 cups, if I remember right.
Not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way
Here comes.
to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about in an investigation. So to say that we didn't introduce that evidence when we tried to do it when we were
I think what Mr. Lally was saying, that you asked questions.
Don't say what Mr. Lally was saying. Say what Mr. Lally said. But here's Yannetti. Hey, we actually tried to introduce this. I don't know if you remember, Judge, but you shot us down. You said, no, we couldn't do it. That's what he's saying. That's what Yannetti is saying. Who cares what Mr. Lally is saying? Mr. Lally gave a dishonest argument, and you know it.
But weren't given answers. And so I think.
But they were given answers. That's a lie. God, I wish they had the transcript right in front of them to go to those questions.
That's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to.
So she's going to allow him the Bowden argument and the Bowden instruction. Thank goodness. Apologize for my anger earlier. I guess I'm okay with that ruling. I guess it shouldn't be necessary. My internet is slowing down. 1 second. When she said I disagree with you on Bowden, I thought she was talking to Yannetti, but turns out she was talking to Lally. Thank God. I hate that YouTube does this.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial.
Okay, so here's the thing, and I think we're about to find something out about the pretrial ruling as to why the case was conducted in the way it was. Bev is not allowing them to make the argument that Brian Higgins or Brian Albert were the culprits, that they were the murderers here, and that was an intentional give by the Karen Reed team. I don't think that they're actually asking for that. I don't think that. So when you make a third party culprit argument, the burden basically shifts onto the defense to make the argument that this is the person who did it. And they have to show, I think by preponderance of the evidence, that is, a more likely than not outcome. I think I don't hold me to that. I don't actually know if that's the standard. I suppose I can look it up. Massachusetts third party culprit. A trial judge. Cool. What? In Massachusetts criminal law, the concept of a third-party culprit defense relates to evidence that suggests someone other than the defendant committed the crime charged. This is an important defense strategy as it can raise reasonable doubt about the defendant's guilt by pointing to an alternative explanation of that crime. It involves presenting evidence. The evidence is admissible if it has substantial probative value and is deemed relevant by the court, must not be too remote, speculative, or likely to confuse a jury. If the evidence is otherwise inadmissible, it must have substantial connecting links to the crime. The judge is not required to give a specific jury instruction on a third-party culprit as long as the overall instructions make it clear that the prosecution must prove the defendant's guilt beyond a reasonable doubt. The prosecution does not need to prove that a third party is not guilty. It is important to note that this defense cannot be based on speculation. Evidence regarding an inadequate police investigation noted as Bowden evidence is related but distinct from a third-party culprit defense. So, the third-party culprit defense, it's a burden shift. You have to actually prove it out to some level, not to beyond a reasonable doubt. And I don't know what the evidentiary standard is, but you have to at least introduce evidence that says, no, this is what's going on here, and here's the evidence from it, and then you can get an instruction, but it's not required that the judge give that instruction. They're requesting it. It's permissive in this case. I don't think that Karen Reed or her team properly created a third-party culprit situation in this case. I believe that they tried to do that in the first case, and I think that kind of bogged down and confused the jury, and I think that's probably why they canceled it out for this case. It's really a mess when suddenly the defense is presenting arguments that someone else did this rather than my client didn't do it, someone else did. That's when the blame shifting becomes a burden shift, and that becomes kind of it becomes frustrating and confusing for a jury, in my opinion. So they don't seem to have gone for that tactic here. So I don't think they're asking for it, but we'll see.
That there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate.
Wait, why? So the judge just like, no, sorry, you can't introduce evidence on this person being a third-party culprit. Huh?
But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that.
From the trial I watched, they certainly didn't do it with Brian Albert, but I thought they did it with Brian Higgins. Those text messages make him a suspect, and the his actions at the bar and stuff like that. I think he's got third party culprit written all over his very exciting wiener. But that being said, I just don't think it's the defense's main strategy here. And I don't think it's a winning strategy. I don't think it's required to win this case. I don't think they needed to do that. I think that they probably learned it was an overstep. But saying that the threshold wasn't met on Higgins, I think is very wrong by this judge. I think that's an incorrect ruling. Albert, I didn't hear enough testimony about Brian Albert to suggest that he would have third-party culprit motivations. I think the only thing we got was that Albert was in the Sally Port, right? Like that was the only testimony. And it was from the chick who went to the FBI.
Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into...
Okay, so they're going with the Bowden defense. They're not doing the third-party culprit, and that to me is consistent with how they've run the case. So if they were to come in at the end here and be like, "Oh yeah, by the way, we think these guys did it," and they said that at close, I think they made enough to start getting into it with Higgins, but I think their argument would have to be limited to what was presented at bar, right? Which would just mainly be his text messages, and then his potential presence in the Sally Port. And I would say at that point you can make a notion that he was involved in the death. The problem is if Higgins is involved as the third party culprit, right? Then that implicates by logical extension Karen Reed, because Higgins would, like, his motivation would have been getting with Karen Reed, who was also motivated in getting with Higgins, and apparently getting back at John O'Keefe or getting revenge on him for cheating on her. And I think that puts her in a really bad light. Like, you definitely don't want that to be the connecting sort of concept in the minds of the jury, that Brian Higgins did this because he was trying to pound one out on her leaky balloon knot. Like, if that's what your argument is, you're really scraping on that one, and you're implicating your own client. And it's probably why they ditched it as a potential defense strategy. It just doesn't end up looking good, even if it might be true.
Third party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
Sorry for the balloon knot comment.
Yeah. So Misty and Eddie, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Commonwealth does have an objection to the teaching instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Misty and Eddie, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Yes, obviously they should have.
Obviously, it's not the strongest DG Batista argument that we would have. It does not occur at a police station, but these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory.
Police interview Karen Reed at her parents' home. Do you think she felt free to leave when the police are interviewing her about the murder of her boyfriend? No, so it's obviously a custodial interrogation. I don't think any Fourth Amendment analysis has her not under custodial interrogation, 4th, 5th, and 6th, has her under any illusion that she's not in a custodial interrogation when the police are interviewing her about the murder of her boyfriend. But they didn't record the interview. They just couldn't find a way to do it. Like, it was just too hard. I don't know what we're going to do. I mean, we don't have body cams We don't have cell phones. We don't have mini recorders that we carry every single place on earth. Like, what were we? We weren't at the station, so how could we possibly record this interview? Instead, they recorded it in air quotes via handwritten notes and summarized notes. Those summarized notes are bullshit. Cops write things down wrong all the time. In my own case, for example, the cops wrote down that this one person reported that my children were wearing the same clothes multiple days in a row. In their recorded police interview, they corrected it and said, yeah, that wasn't actually right. She didn't say that at all. In fact, don't know where that line came from. But that's what the police wrote down. That's what the cops wrote. Kind of wish they would have recorded that report rather than just the notes of it, right? Because if they got a detail wrong on the notes, well, it was just a harmless error. I mean, that detail could have been what sent a judge over the edge to go ahead and allow a warrant to kick down my door. Could have been. Who knows? Don't know. It was definitely part of the consideration. And the person who allegedly said it said, no, that's wrong. That's not what I said. But we don't have a recording, do we? Because the cops just took down notes. This happens every day, every single day in every state. They're all like this. They're all like this.
Of what my client said or didn't say when there was a possibility for a recording, so we still think we're entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could.
Custodial interrogation analysis is very simple. Would a reasonable person under the same circumstances feel free to get up and walk away? So he's saying the police refuse to sit down. They're standing in they're standing in front of her as she's sitting down or standing up. It doesn't really matter. They're standing in front of her in a confrontational manner. Is she free to leave? She said, bye guys, I have to go. What happens? And the question is not, did she say bye guys? It's would a reasonable person feel comfortable saying bye guys, I have to go in that moment? Or would they think that they have to stay, are required to stay by the presence of the police officers? The reasonable person standard under custodial interrogation analysis is not complicated. You have police officers standing over you while you sit down. Do you feel free to go? Do you feel free? I'm telling you. Do you feel free?
All right, what do you say about all this, Mr.
And
Allen?
if I would also add, Your Honor,
Sure.
they did seize her vehicle around the same time. So, that it goes definitely to the issue of custody and my client being able to not answer.
All right. What do you say?
That's the very nature of the objection, Your Honor, the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day.
No, they didn't. Not with a number of witnesses. Stop lying. Stop lying, you commie. They left all of the witnesses out. They just didn't ask anybody. That was the amazing part. They didn't do the interviews, which you have now argued that you've tried to argue that Karen Reed's defense team cannot bring up in their closing arguments. Hold on. Just tweeting out again. I like to do that every now and then. Oh my God, just spell check the fucking word for me, please. Oh, I spelled it right. Go me. Oh, I'm just tweeting out, letting people know we're live talking about this stuff again. You have to just constantly promote. Gets annoying. But also, who cares? Okay. Back to it. I hate Lally. I hate the entire prosecution. I've never even heard this woman talk, and she looks horrible. Brandon looks like me back in law school. Like, I'm typing up my paper in class right now.
Well, of course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from meeting. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they developed from the course of the day and on statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions or requested remaining practice, and then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the main practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted to get into any details. And then when the questions became centered on, more centered on details, at that point, and I know that's not evidence before the jury, but of course, well aware.
Oh yeah, the captions on the court screen. My bad.
So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of these instructions. So I would ask basically that everything on page 8 prior to the Bowden instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And, Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at her residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
Yeah.
I think that's fair.
Okay. Okay. All right.
So I think they're saying that her immediate comments should allow for a compromised mental state instruction, since the state is arguing and has presented evidence that she may have been intoxicated at the time. However, her interview later at the house, there's not sufficient evidence to give a compromised mental state instruction there, and the defense seems to agree.
Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the drop that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Drawing.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
So you guys are gonna maybe hate me for this, but I'm gonna be gone almost all of tomorrow. So I'm gonna miss closing arguments. Which I don't want to do, but I have kids up at camp that I'm going to pick up, and that's just how it goes. It's a family tradition. We always pick up our kids from camp. Personally, we don't send other people to do it, and so yeah, I'll be there for that. But I'm going to come back, and I don't know exactly what time that is, but I'll be doing we'll cover the closing arguments. That's going to happen, but I won't be there during the live closing arguments. So very sorry about that.
I think that was taken into account for the dispatcher.
Will I do a verdict watch? Probably.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I'll probably get back
Okay, thank you.
before closing is done and just start over, and then we'll
Do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
reminder. We have 50
What page you on?
We have all
Okay.
stuff that we can still find this.
Now, the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation.
Every day, I am more shocked how fucked the judge is, in this case, unbelievable.
Yeah. But again, as I screamed before, it's not this case, it's every case. Jonathan Devereaux asked me what time. I think I'll be starting a stream up between 2 and 3 p.m. Central tomorrow. There's no lunch. And I think just adjusting for the potential of things taking longer than planned, I think that I'll be back by I think I'll be back around 1:00 from picking them up. So saying 2 to 3 Central is a nice buffer time. But I'll try and hammer that out and make announcements on it. I don't want to keep people in the dark on it. I don't know off the top of my head.
Preparation for trial. Do you both want this?
Wow.
There was testimony on both.
Have to eat all the cannoli I can handle. I love how it drips down the flavor saver.
I really, really hate that. We're going to play it again because part of it got cut off.
Sorry, guys, I'm not going to be here tomorrow. I'm going to Camp Bev to eat all the cannoli I can handle. I love how it drips down the flavor saver.
So gross. That's so gross. That is so disgusting.
Sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it, witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
That was 307 fishing. I will not ban 307 fishing from the chat, but they can be shamed. They can be shamed for this. Shame. For shame. What? Who hurt you?
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when prepared.
Yeah, well, you had a sequestration order, but you also just allowed both sides to completely ignore it with their ongoing expert witness testimony battle that you could have prevented from happening by just allowing a proper schedule and enforcing it upon the state instead of trying to put the entire burden on the defense. But, you know, that one wasn't an own goal there, Bev.
Preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give.
I'm really, really curious on the consciousness of guilt thing. I think she's going to fully allow a consciousness of guilt argument and offer a consciousness of guilt instruction. I think it is the biggest mistake that the defense made, specifically Attorney Alan Jackson, by allowing the consciousness of guilt argument to go unchecked and unobjected to when Hank Brennan made it. And I wonder if she's going to mention that. Here we go. Of course, she said she'll come back to it, so we'll probably never hear it.
The prior bad acts instruction, I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave.
Is my mic being cut off like every time if I talk at the same time as trial? I think I cranked it up just a little too high on the volume boost.
Gave the prior bad acts instruction.
Hopefully this is better. Nice suit. Where'd you get it?
Testified.
Yes. The jacket actually is from a French store. Yes. How'd you know?
Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so. All right.
I do
I
not.
think I have to add that here.
I have a doctor's appointment. But
So,
I put on the
all right.
jacket because I'm wearing this tie.
And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a
You're
look at that,
cutting out
Mr.
a lot.
Lacey. All right. Consciousness of guilt.
I probably need to swap out my microphone.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up.
When the video isn't playing, I'm perfectly clear. That's StreamYard then. Hold on. Let's try it this way. I think it. Hopefully this will work better.
Okay.
Whatever app you're using for audio. StreamYard has just shitty mixing.
Speak up.
Now there's an echo. What about now?
Okay.
Does this fix it? Can you hear the court now?
Do you have supportive case law for me to single this out? What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended
I can crank my mic a little bit.
to read his father's name.
Maybe this will help.
It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at the position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement.
Problem is the Yannetti and Lally are so
If you
far
can get
away
me a
from
case by
microphones.
this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model.
He should say, "I'll try and find you a case."
I'll
by
see
this
if there's something
afternoon."
I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can
loud.
find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
Yeah, I asked Lady Raggets to bring me my other mic. This
You know,
would
I
maybe
could also, I
going through
suppose
some
I could
trouble.
always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe.
Gary's better mic.
Maybe
Sorry.
I'll do that, but let me see if I can find
read Rumble
something.
chat,
If I can
too.
find something that says I don't have to
But I
give
may
those
have missed
first two
whatever
prongs,
your thing is.
I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing.
Who are you over on Rumble chat?
If I alter it, it
different
means I
name.
remove those two. That's all.
But no, we just want
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? You were.
we're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text message.
Hopefully-
we have a redacted.
Hopefully this
version
fixes
now.
the audio, maybe.
We'd like to submit to the court of the copy to the
I took
Commonwealth.
off the automatic
Recall that
volume
we
adjustment.
agreed essentially on a redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh.
But I'm going to
Okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so.
The only other issue, Your Honor, is we do have a...
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf.
Can't wait for Alessi.
To be introduced to the evidence from
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have to redact it, so these
Okay.
are redacted. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor.
Derek Boodle, will Bev explain Brendan's lie about the hoodie? Not a chance. Hoobie Star says, what are we angry about currently, this travesty or another? This one earlier, just the ruling on the motion for a directed verdict from the court of not guilty, and the just a frustrating reality of the justice system as it applies to this case, but also to every criminal case that hits trial.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, and I hand the
Okay.
proposed copy to the court.
Sure. Is it the same as last year's, but now with a?
It's different.
Okay.
Lady
right.
Rafford says, seeing a request for my other microphone.
Digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually an
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements
Thank you.
that are different for each
I like your
lesser
outfit.
included. And we were uncomfortable with, there being one option for
She
not
looks
guilty
adorable.
at the top of the form, and then multiple options for multiple different.
Here, one
types of
second, guys.
guilty verdicts. Well,
I'm going to switch microphones, which means I have to mute it or else you guys will go deaf. 1 second. Test, test, test. Hopefully this is working well. The same microphone, one's just black. For whatever reason, it's not working as hard. I don't know. Obligatory racist joke. I'm sorry. I'm a product of a bad generation. It's not my fault. No, I think maybe the other microphone sustained some damage. While I was hooked up to the karaoke stand, I know the kids knocked over the mic stand. Well, the dog. The dog knocked over one of the mic stands, so hopefully this is better.
the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording.
I think lesser included offenses like this are absolute bullshit. What he just described is the most anti-justice thing that you can think of. The state proposes a criminal, they propose a criminal infraction and a proper punishment, right? And they don't get it. And the jury is then allowed to go down a list of lesser included offenses. Like, well, if you don't get to this one, maybe they got to this one. Well, if they didn't get to there, maybe they got to this one and this one and this one and this one. And it allows the juries to go, you know what? I don't really like this one, but I think someone should be punished for this. And then to peg, to peg the punishment where they think the punishment should be related to the offense rather than the evidence. If the state is asking for second-degree murder, the state needs to present evidence of second-degree murder. If they can't meet the burden, it should be over. That's it. That's it. They shouldn't get a lesser included offense. Well, if we couldn't prove, the malice, then we should get manslaughter. No, you shouldn't. No, you shouldn't. You should get manslaughter if you can prove the recklessness specifically, not because you couldn't prove the malicious intent. The reckless disregard for the safety of others. Like, you don't automatically have the evidence of that just because you didn't prove that they intentionally did it. And that's a problem because the jury is not, they're not qualified legal analysts. That's not the jury's job. The jury's job is to put forth the factual record that they believe is the most accurate and then measure it against the charge. Once you start adding in all these alternative considerations, you start taking away the analysis of the evidence. You start taking away the analysis of whether or not guilt has occurred beyond a reasonable doubt. And instead, you offer a smorgasbord of options for the jury to pick from to make themselves feel good or to make emotional decisions. Every single step away from a targeted prosecution with a targeted verdict is one towards the human condition rather than the facts and the evidence. And that's injustice. Period, period, period. There is no justification for lesser included offenses. The state needs to prove what happened. They don't get to shoot for the moon and then accept a satellite. And I hate that idea that they do.
Would I stuff Bev's cannoli only with Johnny Depp's Maker's Mark bottle?
Oh, no. I hate that. That's horrible. God, it was such a nasty story, wasn't it? Like, it was so unbelievable.
I have a question. Who's the mean, not so lean pedo pizza casserole eating micropene machine?
I only came for pizza casserole pedophilia, and it looks like we are out of pizza casserole. Hey, Diddy, got any oil for this micropene?
Oh, my. Oh, my. Let's see. We have, I think we had to do what? One of those. Save and one of these. And we'll just go ahead and say, I hate it. I hate everything about it. What is happening in the chat? You guys are crazy. You have severe mental illness. Like, I called you crazy, but you also, like, come on. This cannoli stuff, this has got to stop. This is disgusting. All right, back to Yannetti up here, who's doing an okay job holding down the fort. I mean, he's up against an impossible opponent in Bev Cannoli. Cannoni. I hate you. Ah!
You'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.0 weight or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth.
Righteously indignant rackets can stuff my cannoli with his brutha butter.
Your Honor, why are we letting this obviously guilty woman's lawyers have a say in closing?
You're right. I don't want to be here longer than needed. I mean, I'd like to finish early, like Kurt's micropene and my golden cannoli.
Allie, you're banned. You're banned forever. Ew. Ew, ew, ew. No.
I heard that someone purchased a $20 ham sandwich today. I would like to make you aware it goes well with roast beef if you would like to eat it out of my cannoli.
What happened? Why is the cannoli a thing now? I don't like this.
No, I think any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, Commonwealth Smith, is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues. And, I believe used at least part of the verdict.
Honorable
first trial in this case as sort of a template for the lesser included to be instructed and the verdicts that they utilize in action. I don't have a copy of it on me, but I can certainly get the court a copy with a copy of the docket, but that may be somewhat helpful if the court is thinking of
Okay, was that on murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're...
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
Docketed.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy?
Sure.
This is the
Yes.
Time is a glorious time.
Or, you know what, just mark it for identification, Margaret.
Thermasia says cream-filled cannoli, that is all. I have to ban my entire old chat.
We'll do that. Chrissy, please. Just for ID.
it's LLLL for ID.
LLLL. Sounds like my last year.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in its arguments to the jury related to specific areas which we would need judicial approval before we consider. So the two areas that are sort of listed within that we would like to make some arguments to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips of the way of her statements.
Okay.
In particular, would be the one where essentially she says it's a certificate to her.
Okay.
The exact location.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes,
Bev, you weigh in on everything, you hog.
Sorry, everyone. I won't be here tomorrow. I'll be too busy cannibalizing that sweet nut nectar and leftover Brutha butter out of Bev's leaky cannoli knot instead.
Kurt has a micropene.
Unacceptable. It's just you people are unacceptable.
To that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. And in fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give,
Hey, now the
even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
I'm dumb. Now the captions don't cover up the.
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? Okay.
Holy shit! I missed this. I was too busy. Hold on. Sorry. I need to go back to this.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the consciousness of guilt instruction. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in these arguments to the jury related to specific areas which we would need judicial approval before we so the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from when Metal Dad came to her parents' residence indictment, and then certain statements made in reference from the various clips of the later.
Okay, so this is what Brennan argued for in those video clips. Specifically, this is the argument that Brennan made. Those two video clips show that her taking of the car is consciousness of guilt, and also the way she reacted to John O'Keefe's mother, and the way she was looking at Karen Reed and treating her. This is directly on point with that. Sorry, I missed it a second ago. I was having too much fun playing around with other things. That's my bad. That's my bad. I've been accused of doing that on trial, on stream before, but this time it was true.
Boys, this is the perfect time to cream pie a cannoli if you have penicillin handy. Otherwise, I will suggest you stand behind to Oklahoma hand grenade or a Portuguese snowblower.
What is wrong with you? What's a Portuguese snowblower? I want to know. I really want to know. Whatever that is.
Oh, sweet, sweet Kurt. Please make sure mascarpone cheese isn't the only kind of cheese in my cannoli. Stuff it with micropene cheese.
You guys should lose your privileges. I shouldn't be indulging this. Y'all are children.
Okay.
In particular, would be the one where essentially she says it's certificated to her.
Okay.
Guy's so quiet.
All right. Ms. Tianetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me.
How are you going to object to it now? Alan Jackson said he was okay with it at the time. This one, I'm really curious how Bev's going to rule on this, because their objection to it now is problematic. They said they were okay with this when it happened, which I think was a mistake, but they did say that.
Being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clips.
Yes, so I did want to ask you, though, Ms. Gianetti.
I don't agree. This sucks because I'm arguing on behalf of the state here. I don't agree with Bev here. I think she should give the instruction because I think the state earned it, and I think that Karen Reed's defense team said they were okay with it. Now, that said, I'm glad she's not. I'm glad she's not. She is going to allow the state to make the argument. And technically, that is consistent with what Brennan did. He said, we intend to argue. We intend to argue this. And so that is a consistent decision, I will say. I think the defense just got actually a big break there. I mean, Brennan is still going to hammer on that point in his closing arguments, excuse me. He's going to hammer on it in his closing arguments, and she's going to let him. And I think at a real law level that that's an absolutely impermissible inference, and I think it's wrong. I think it's entirely wrong that this is coming in. However, just due to the way courtroom motion practice plays out, I think the defense effectively let it in. And so I'm kind of surprised by this ruling in that way. But that said, she's going to let it go. I think Hank's going to hammer on that heavily. I think that's going to be a big part of his argument. I mean, we already know that the biggest part of his argument is her consciousness of guilt, is her saying, I hit him, I hit him, I hit him. That's their entire theory of the case. And so I think he's going to lay into this, and she's going to let him do it. And there won't be proper objections from the defense on it, but she's not going to provide a specific instruction. Now, which is interesting because she said, well, there's good stuff in there for the defense too. So why was she even hesitating? And maybe that's why she was hesitating. Man, I think this is the riskiest part of the case for the defense. Personally, I think this is where the sneakiness happens, and I think this is where the most danger is for their client.
There was a man named Kurt who just wanted his micropene to squirt. No lady could be found for this task. It's way too much to ask. So he's alone with his Willie eating his chili waiting for his micropene queen.
Micropene queen. Now we're sharing the same scene. Grains of rice look twice as fun. I don't know where to go with it. After that, that's it. That's all I got. It's terrible.
I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Unetti? We're going to hear from Mr. Alessi, but...
The Commonwealth does not object to the redaction.
That's great, thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
We want to redact every Higgins message in which he claims to be a fun guy because he's not. He's not, and it's obvious. Go for Big Guy 911 says, first time tuning in 2 weeks. What do you think, Rackets? Well, I think you should be here more often than once every 2 weeks. I think that's irredeemable. That being said, I think a lot of things. I think injustice occurs in this trial, but I think it occurs in every trial just about. I'm waiting to be proven wrong on that. That being said, I mean, look, injustice occurs even when people are guilty.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealth's.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that
Just a reminder,
209A? We need, Mr. Yannetti?
I have an hour
We
and
need
10
to
minutes or
keep
so, and then I
record
have
of
to
the
go.
first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can stay there.
Okay.
But is this the-
Oh, it's just NNN. It's not.
Well, where did it go?
No, it became 209.
So that has to
Our
be-
thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MMMM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
What a great name, Nicholas Hooker in the chat. What's up, Nicholas Hooker? Karen Reed is guilty, but I am not a hooker, so how dare you?
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office.
By the way, I don't know if you guys know this, but if you want to send in a super tip with a link, those allow links. You can just do a text one. I think on YouTube I have links turned off unless you're a mod. So if you ever wanted to send in a link or whatever, you can send those in via super tip on any platform. They work that way. Just use the text option instead of the voice option.
So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue.
Is Exhibit 88 the shirt? The back of the shirt? It might be. Very curious. This is in regards, I believe, what was that? Bev said she would give a curative instruction. She said what she would instruct on, and then when she came out and gave the instruction, it was weak. It was nothing. It was nothing like what she said she was going to do. And so Alessi has proposed a proper curative instruction, and Bev said she would get to it at the charging conference. So I believe that's what this is. James Andrew Morrison, extradite, did he mean expedite? Yeah, expedite is, I believe, what he may have even said. When they're not at a mic, the closed captioning struggles.
But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So, Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in final.
Tail between your legs argument is what's happening right here. If you've never seen it, the Commonwealth defers to the court on whatever they want to do because they know they fucked up hard here. And Hank did it intentionally and was like, I made a mistake. He didn't make a mistake. He did it on purpose. He tried to taint the entire jury, and he probably did. Hopefully, they'll just be able to overcome it. But what he did was absolutely malpractice. It was misconduct before the court. It was a lack of candor before the court and the jury. He should be sanctioned for it. And this trial should have been a mistrial at that moment. You don't read the CC, he said extradite. Yeah, then I mean, expedite seems like a more appropriate word than extradite there, but I don't fully remember the context.
The Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of
differing language for further instruction given to the jury during the court's final judgment.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you.
Yell it out, Alessi. Yell at me.
Your
Laura
Honor, I
Daniel.
have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some.
That suit is magnificent. That is vibrant blue. It's beautiful. I love the tie. Obviously, plain white shirt here. People have said you're not commenting enough on the fashion going on before you. I mean, there's just this vivid display of masculine fashion happening, vivid display of transmasculine fashion happening, of course, from the Commonwealth. And I have not been commenting enough. This suit is incredible. That's an expensive ass suit. That is a navy blue that pops. Like, how do you even get that? What the hell is happening? Great job.
Points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are this Exhibit A.
Brandon, I'll give you all the
Exhibit
beach
B,
weddings you
and
can handle.
Those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but...
Oh, the court decided to turn on his mic. He was just yelling into ambient mics the entire time. They're like, oh, crap. We really didn't even notice. That's how loud he is. Can you imagine? Like, this lady is here trying to block the assault of sound coming from this man's voice. She's like, oh my God. She's having a migraine on the spot while getting pregnant from the argument. It's amazing.
I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional.
Yes,
specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And
Yes.
Our proposed curative instruction is on page 2 of our motion. It states, during the
I mean, yes, it's modest. No matter what he says is modest. I believe that this is grounds for mandamus, for an immediate order from a higher court heading down to direct the judge to offer a mistrial with prejudice or a mistrial without prejudice, one of those two. That's the only cure for this. This jury is irrevocably tainted by what Hank Brennan did. There's no way around it. So yes, anything that they demand less than that, which they demanded, in fairness, they demanded mistrial with prejudice, and Bev denied it. I think they should be filing for mandamus order on it immediately.
I'm going to set up a cannoli eating contest to end these proceedings. I've obviously always enjoyed Hank's abilities, but my Nick has my cannoli leaking after hearing his skills. I sure hope you like sour cream mixed with sea salt and vinegar flavor. It's finger or nose licking good.
I object, I object, I object. Even I can't stand this. I must request Tex Vet be held in contempt.
Yeah, Tex Vet. You should be held in death. What is... Ew. No. Gopher Big Guy says, so you think she is guilty? No, I don't think... I don't know. Right? I don't know either way. But the state has presented no evidence that that John O'Keefe was hit by a car at all. And Karen Reed's team has presented significant evidence that he was not hit by a car. So I believe in the context of this trial, there's no way to reach a guilty verdict. So I believe that I think the case should be dismissed. I do not believe the state has entered into evidence sufficient has evidence, I suppose, to make the claim beyond a reasonable doubt. I don't think they've even made it to probable cause at this point. I don't think they ever had a case to bring against Karen Reed. That doesn't mean she didn't do it, but I don't see how she would have done it. And she certainly didn't do it by the state's theory of the case. That's my opinion on it, of course.
Your Honor, who is going to watch the verification that Kurt's micropene and comfortable fit inside of your cannoli? Also, do you mind if I swap an N into the word jigger?
It is not allowed. You're banned for life. How dare you be such a racist monster? Wait, actually, no, I'm the racist. I assumed where the N goes. Maybe it's jigging. He's just out there jigging, right? I don't know why I assumed it was the first letter. That's it doesn't say swap the N for the J. It just says into the word. It could be ginger for all I know. Very racist to me. I shall repudiate myself. Let's go back to this. Looks like court is probably done. Yeah, is done at this point, and we only got about 13 minutes of court left here.
Cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022.
Bestie Rose says, what WTF are you wearing? Look, Bestie Rose, when I was listening to this morning, I wasn't sure if I was going to stream yet. And so I was just listening along as I was deciding. And I got so angry. I had to put on my angry tie, my liberty tie, my justice tie that I got at Goodwill for $4. Here it is. Look at it. It's so funny to me. With a tie, of course, you have to wear a jacket. Otherwise, you look like a computer engineer who's also looking at the wrong kind of pictures. So the only thing worse would be a short sleeve shirt, a tie, and no jacket. That would be a travesty that could not be countenanced.
You sickos, I'm over Bev's cannoli. Stop it.
Me too. But you did mention it, so it goes up. We soldier on.
Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Miss Hart.
Sorry. Hit the wrong button. My bad.
A sentence, so, jurors, I instruct you that those holes were made by the criminalist, Miss Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Because that date you told me was important to you, right?
Among other factors, the date was important.
It's
Among
May
other
18th,
things.
right?
Yes, Your Honor. And so, Your Honor,
There, sorry about the echo.
What is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue.
Alessi's stuck with a dilemma here. This should have ended the trial. It's that bad. It's that bad, and it was done intentionally. They even laid out that specifically the state never introduced the back of that hoodie. The entire trial, the state avoided talking about the back of that hoodie, and they brought it up at this specific moment so that there would have never been testimony about the back of the hoodie and where the cuts on the back of that hoodie came from. We do have testimony about where the cuts going down the front of the hoodie are and where the cuts are going up the sleeves, because they had to remove the hoodie from him. But we only had testimony about those cuts being made by the resuscitative team. There was never testimony about the criminalist making those incisions at all. And so to avoid entirely talking about the cuts on the back of the hoodie is to infer that all the cuts on the hoodie were talked about by the by the witnesses brought forth by the state when they discussed, the removal of the clothing and why there's this extra and obvious damage to the hoodie itself. No one described why there would be those holes in the back, leaving a juror to the reasonable conclusion that those holes came as a result of an accident or whatever happened to Mr. O'Keefe. And the state knew this. The state is 100% aware of what they were doing. Brennan did it on purpose. And when he stands up and says, we made a mistake, the level of intentionality that goes through the entire case, all of it, you have to understand, they did this for 7 weeks on purpose. 7 weeks of deception leading to this moment. This case should be over. And Brennan should be potentially facing sanctions for it. That's how bad of a mistake this was. So Alessi is here trying to argue the ridiculous, that this can be cured by a jury. This is 7 weeks of intentional deception by the Commonwealth. Now, I don't think I've made enough of a point about this in the past. How bad this is, how horrifyingly unjust this is, how unfair it is, and to have Bev Canone sit there in complicit compliance and encouragement for the state by not doing anything other than offering a limp-wristed, half-dicked curative instruction. Fuck her right in the face for exactly this. This is what should have her removed from the bench. It should have Hank Brennan sanctioned, and it should have Karen Reed walking out on a shopping spree right now with her boyfriend, Alan Jackson. Like, that's what should be going on. But no. No, instead we get this poor, I don't want to say poor argument. That's not what's going on. This poor position that Alessi is forced to fight from, where he is supposed to argue somehow that there is an instruction that is sufficient to cure the damage done. That in one line, 7 weeks of intentional misdirection, misconduct, and malicious malpractice has done. That some throwaway sentence from Bev Canone is supposed to fix that.
Rock, flag, and eagle. Always sunny in Philly reference for you uncultured swine who don't know.
I've never watched a single episode of Always Sunny in Philadelphia.
Yay, Mr. Alessi, tether me, daddy. Tie me up with one of your ties. Just remember, I only consent to eating cannoli. Don't try and sneak in an Oklahoma teapot again, unless needed to fill Bev's cannoli.
An Oklahoma teapot? I don't even know if these are real, and I'm a degenerate. I'm a horrific monster, and I don't even know if what you're saying is true. I don't know if that's a real thing or not. Now, I don't want to do the research to find out.
So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I bet
they could be going straight for mandamus, not just statements. They could be going for mandamus. They could be going for sanctions against Bev, and they're not. They'll wait till the ultimate outcome of the case and then just file an appeal if they lose. But I honestly believe that they should be asking for mandamus, because if they lose, the appeal's going to take forever, and Karen Reed will sit in prison. That's insane. Billdozer74 says, why the suit? I demand a gay shirt. Also, Weinstein got a mistrial on the remaining charge. The Weinstein stuff is tough because he's a dirtbag, but a lot of his actions are hard to show to be criminal. Jake Hudson says, hi, Nick. I would love to have you on my show. Please consider it. I consider every show request, Jake, but I don't know that I'll accept or not. I certainly have gotten some of your requests. Lately, I haven't been doing a lot of guesting outside of people that I know very well or have a very intentional purpose for guesting with. But I will, I'll keep considering. You're welcome to keep sending the requests.
and in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with
it was the heat of the moment. Sorry.
The witness on stand. Things can happen. Mistakes can be recognized,
acknowledged, and accepted.
Oh, they turned on the mic right in front of him. Thanks. All day they haven't been doing this, but they finally decided to. Listen, look, in the heat of trial, you know, anything can happen. In the heat of trial, who's sitting there going, man, trial's just so rapid fire that these attorneys couldn't possibly have thought through this. Like, they just completely taken aback by the wild action happening in front of them. Who believes this nonsense? It's crazy.
As a mistake, there were numerous offers by the Commonwealth to offer a...
Who cares if this is a mistake? Who cares? It doesn't matter that this was a mistake. This is an incurable mistake. Whether you call it intentional or a mistake is a matter for the sanctioning board, not a matter for the trial court. The trial court needs to only consider if this sufficiently prejudiced the defendant to the point where they cannot mount a fair defense. And that unequivocally happened. This is disgusting.
A stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay.
Unreal. They didn't get a curative instruction. They got a bogus statement from Bev Canoni that didn't address the issues at all. And there are other remedies, and mistrial is one of them, and you know it. But an explanation directly to the jury that, yeah, these cuts, like, you don't understand because I didn't say it properly before. These cuts were made by the state's criminologist. They could not have been made in any other way. They were not made in any way on the night of January 29th. They were made in May in a lab after this shirt sat on the ground of, or on the floor of a Jeep of one of the investigators. They were not made on the night of the incident in question. They cannot be considered in any way. And any inference that these cuts in the fabric came from either an impact with a car or anything else on the night of the 29th is impossible. We know for a fact exactly when these cuts were made. The state was unclear in how they presented this evidence before you. The state has made sufficient apologies outside of your presence, but we wanted to clarify these facts. The fact of this case, you do not have to find it, jury, because we know factually the state and the defense agree that these cuts happened in May and cannot be considered on the night of the incident. That's the kind of curative instruction that comes close to undoing the damage that was done. And anything short of that is not sufficient. Period, 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 period. And now I'm thinking of strawberry stuffed cannolis. Thank you.
So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45 ready to start. So things take a little while generally. That will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll have counsel here at 8:30. All right, thank you.
All rise to the court, please.
Is there already one of these? Like, are we swapping?
Yes.
Goodbye.
All right, there we go. That's all of court for today. So we actually caught up. That's cool. Before my doctor's appointment. Oh my gosh. This trial is going to end. Friday is going to be closing arguments, and then it'll be verdict watch. We'll see what happens. Whew. Nailing maps to the wall since 1969 says, problem, I can fix some of them. What we talking? Sounds like you're the kind of person who fixes the problems that none of us like. Let's go, Brandon. Welcome to paralegal status. Really appreciate that. Thanks for joining.
Strawberry cannoli are the closest thing I've heard into a pizza casserole in a while. Let's take my white van to the border and see what walks in. Also micropeen.
No. Oh, God. This is not good. Not acceptable. Darkness Light says your doctor is going to see that tie and go, wow, I'm setting stream today. I'm not going to wear this tie to the doctor. This jacket is making me die of heat exhaustion, but Octavia Lucky Girl. No, I only wore the suit for the stream. I'm not wearing the suit the rest of the day. As soon as I'm off stream, I'll be shedding the jacket, shedding the tie. I'm probably changing shirts. It's I think it's warm out today. Let me see. Sleeping psychopathy because today merited it. Oh my gosh, it's 63 degrees. Okay, well, I probably will wear something more substantial than a tank top at least. You're tired of hearing about the jacket. Okay, I have to leave in 30 minutes. So I think there's only one thing to do. We have to do this, right? We have 30 minutes left. I think we need to soldier on into this breakfast casserole. And you know it needs to happen. We're not going to finish it. Don't worry. We're not going to finish it today. Soup time is a glorious time. Someone asked for like a summary recap. The summary recap is they worked out the proposed jury instructions. It's actually one of the fastest jury instruction days we've watched on the channel. There wasn't much debate over it. There were a couple motions by the defense and to mixed results. The defense's big win is getting a Bowden instruction, although that isn't the biggest win on the planet. It is significant, and they needed to do it. So I'm glad that they did. Other than that, really, we'll just have to see how closing arguments go. Gosh, I don't even know. Does anybody know what this creature is that's hovering over the bowl of eggs? That's a hand. That's a wrist and a hand. Somewhere the wrist turns into a hand, and I don't know where. It's one of the most horrifying things I've ever seen. By the way, please hit the like button on the if you're either checking in or checking out. Either way, I understand the Cooking with Kurt content isn't for everybody, and that's fine. But if you enjoyed the stream so far, please slap that like button. I really appreciate it. It helps YouTube know that people actually do want to watch this content. So
great. Who likes scrambled eggs?
I mean, everybody likes scrambled eggs, except for very few people who don't like eggs, and those people should be cast into the sea. And I'm sorry if you're in the chat, but you belong in the ocean.
Actually, I do actually have a whisk. I can actually use to whisk them.
Oh, yeah.
Like a normal person.
Let me see how you whisk
Instead
it,
of just using a fork.
No, whisk it.
What if I used a whisk? Like,
Whisk it
to
good.
whisk with? That might be good.
I think there were 14 eggs. If I remember right, there were 14 eggs in his single-person breakfast casserole.
Your Honor, asking the jury to stay until 5:30 on Friday the 13th before No King's Weekend is cruel and unusual punishment.
I agree. Jonathan Devereaux, he's not making scrambled eggs. He's making a breakfast casserole, which he claims he will not eat in one sitting. I'm pressing X to doubt as much as possible. Island, no, being allergic to something is not the same as not liking it. That is entirely excusable. You're forgiven. That's not your fault. It's not like you made that decision. What are you doing with that whisk? Why'd you bother? This isn't whisking. You're never getting to peaks with that thing. Stop it.
All right.
Oh, you didn't even whisk
To this, I am going to add 1 cup of heavy whipping cream. So let's go ahead and do that. Where is my measures? They're around here somewhere.
Cup of heavy whipping cream. Can we discuss how much a cup of heavy whipping cream is? 14 eggs is a lot, but a cup? Why are you even adding heavy whipping cream to this? What do you... Wow!
Heavy whipping cream. One cup.
1 cup of heavy whipping cream is 1/3 of a cup of saturated fat. It's so disgusting. Don't get me wrong. I love heavy whipping cream in the appropriate amounts, in the appropriate context, right? I love it. It's fantastic. I like to put, like a tablespoon of it into a glass of sweet tea, maybe 2 tablespoons into a glass of sweet tea with some vanilla. I think that's great. It's healthier to do it with whole milk, though, and you get roughly the exact same result. So there's no purpose in using heavy whipping cream to do so. You just like the fat content. There's no reward to the fat content itself.
Me, the Tex vet, am a strong man, and even I wouldn't eat that many eggs for breakfast. My breakfast is 2 full eggs and 6 whites, and that's a lot.
That's a lot.
And I'm a huge guy at 6'4", 375.
Yeah, I used to eat 6 egg omelets, and I always felt terrible after doing it. I mean, I just like omelets enough that I would eat a 6 egg omelet. But But I found like a 3-egg omelet is better in general. It's the same like level of satiation for me, and they're more manageable in the pan and stuff like that. 6-egg omelets are too, like, the egg gets too fluffy unless you have like a 14-inch pan. Then you got this big fucking omelet that doesn't go on a plate. It doesn't make any sense. 6-egg omelets, that was a ton of food. It was way too much. I could only do that when I was very, very physically active. Back when I was playing, I played soccer a lot for a while, and when I was marathon training, you know, that made sense. It doesn't make sense for a normal human who's just like living and working.
Okay. And we will go ahead and whisk that in.
When I was eating 6-egg omelets, I was eating 4,000 to 5,000 calories a day because I was working out sufficiently to do that. I haven't done that in years. Why are you rolling the whisk? You're not a machine. What is this? Come on. The entire purpose of the whisk is to pull eggs up and to incorporate air into the eggs to make them fluffy. That's why you're using a whisk on this recipe. There's no other reason. Whatever you're doing is wrong. Stop it immediately. Go to prison.
I think that's looking pretty good, don't you?
It's not. No, it doesn't look good at all.
All right, let's take a look
It looks
at our
like
meat,
cream.
which has been browned in this pan.
No! He's just boiling meat again. There's no brown on it because there's nowhere for the liquid to go. You know, you don't even have, like, if you're gonna do this, you don't even have to brown the meat. You could just put the meat in raw and cook it for 45 minutes. The meat will cook. If you're going to put it in an oven at 350 degrees for 45 minutes, you're going to cook the meat. You're going to boil it in eggs just the same as you're boiling it in the pan. Doesn't matter at all. I'm angry. I'm mad about this. I'm so, like, this is wrong. It's wrong at a primal level. Ugh. Like, just get one of those ground beef choppers for the pan, like, at least.
That needs more oil, I think.
No, it doesn't. No. What are you talking about? It needs more oil. Here it comes. Oh, God. Yeah. He just dumps olive oil on top of it. It needs more oil. No, the Titanic needed more oil. This doesn't.
Oh, yeah. It smells nice.
No, it doesn't. It doesn't smell nice. I can smell it from here. It smells like my nightmares. Oh.
And pretty sure we can charge you under Geneva for this. Cruel and unusual punishment. Also, the way Kurt is treating that meat makes me want to side with Peter just to stop him.
I'm going to become a vegan. Oh. He can't figure out why it's not cooking. It's like, why isn't it cooking? Why isn't it getting all, why is it still so pink?
All right, that's coming along very nicely, I think. Num, num, num.
Oh.
All right, so to this, we can go ahead and add some, we're going to add 5 ounces of Worcestershire sauce. Helps bring out the flavor, I find, very nicely.
I turned up the super chat, or super tip volume. If anyone wants to test it out, go ahead and send it to me.
5 ounces Leon
Or send me
pepper.
one.
5 ounces of Worcestershire sauce. We're adding this whole.
Wait. He's going to put a whole bottle, an entire bottle of Worcestershire sauce into this? I'm sorry. I'm sorry. Wait, what? What is happening? Why? Why would you do this? There are villages that could use that sauce, and you're going to just put all of it in a whole bottle? I don't know that I've ever finished out a bottle of Worcestershire sauce. I barely ever use it, only when specific, recipes call for it. And you're really talking about a couple tablespoons at most, 5 ounces.
His eggs look like the custard the Teletubbies eat. Atrocious. And now adding Worcestershire sauce, make it stop.
Wow, the volume booster on Super Tips doesn't do anything. That's kind of wild. Let me see if I can boost them on OBS. Oh, I can. Here we go. That should fix it.
Like this.
Who would eat this? Show of hands in the chat. I know one of you degenerates out there is like, you know what? I'm fine with it. Who would eat this? Someone, be honest. I won't ban you this time, but I need to know who's out there who's like, you know what? This looks great. Orion says, if you think this is bad, look up DSP making a tuna sandwich. No. Nope. Normie's TV says me. Normie's TV, I'm going to find a way to make this for you, to follow Kurt's special recipe and make this for you. I don't know how, but I want to do it. The Iceman says, I'm a tub of morbid obesity. 3 egg omelets fill me. Yeah, not all fat people eat like giant, like hippos, right? Like not all fat people are just consuming massive amount of calories per meal. I think a lot of people's struggles with weight have to do with 2 things. 1, a low activity level, but 2, more importantly, snacking. I think snacking is what actually causes most of it. People don't figure in the amount of calories that they're consuming through drinks and the amount of calories that they consume through little snacks that they have throughout the day. And some people, snacking has just become such second nature to them. They'll grab a bag of chips here and there. When I was driving around a lot and I was doing my law practice, I would stop and I would grab those the big cup Reese's peanut butter cups constantly, or before those came out, I would grab the king size packs with 4 Reese's peanut butter cups and I'd eat them. And those are like 500 calories, and I'd eat those, or I'd eat a 2-pack of Snickers or whatever, which is I think 420 calories. So it's like those types of things would just stack up throughout the day, and you kind of ignore them. But that's what I think that's what really gets a lot of people. It's not that they just, I mean, Kurt is here eating disgusting meals, but not everybody's like that. Sleeping Psychopath, he says, you'd have to add dandruff to the casserole. We'll source some from a homeless guy. We'll find some.
Sir, you cannot put an entire bottle of Worcestershire sauce into anything unless you need some lubrication to bang an entire cattle carcass with your micropene. First-degree cooking abuse, PRE trial.
Pre-trial. All right. Reminder, I have to go in 14 minutes. I have a hard out. Yeah. So I'll be taking off in 14 minutes. Let's go.
Great. Easy enough.
What color are these eggs even going to be when he stirs it up? Egg time is a glorious time. Oh, look at it. It's its own private lake, trying not to incorporate into that albumin. The humming is like a serial killer, like peeling the skin off his victim's carcass.
5 ounces. 5 ounces. 5-ounce bottle.
Sweet time, it's like glorious time.
So there is now 14 eggs in the bowl, 1 cup of heavy whipping cream, and 5 ounces of Worcestershire sauce. That is what is now in the bowl. For those of you keeping track of
Filthy pools of beef, pork sausage, and olive oil it's going right into your arteries. You know he's going to just pour it in there. Am I gagging over Kurt's casserole or just coughing? You'll never know. But I think you know. I'm also coughing. Do you want to see Kurt make a salad?
How many servings does this make?
Here's 4 pounds of
I don't
ground
know.
beef for the salad.
How hungry are you?
How many servings does this make? I don't know. How hungry are you? 7. That's 7 servings at minimum. You have, and I'm giving you some forgiveness on, that's 2 eggs. That's 2 eggs and almost a half pound of meat per serving if you go with 7. That's 7 servings for a fucking monster. Ah! Ah! Like Sarah Bill says, he has 5 pounds of cheese on the bingo card. I'm pretty sure it's he's only got 1.5 pounds of cheese to put in there. He's got 3 8-ounce bags of his favorite melting cheese, which has Philadelphia cream cheese in it from Kraft. That it's a very high fat shredded cheese, which is great. I mean, if you're gonna put shredded cheese in something that's pre-shredded, I guess do that. In all that fun little powder that keeps the cheese from touching the other cheese, I guess.
You may need a second casserole dish because of how much stuff is in this dish. We'll see.
A second one.
Fortunately, we have a second casserole dish if we need it, so that's not a problem.
I'm not surprised by this at all.
All right, now I'm going to add in some hot sauce to the dish, to the
How much?
eggs.
You're not showing us how much.
Fairly generous amount here. Am I measuring this out? Nope.
Do you hear it? Do you hear it? Sounds like an 80-year-old man peeing.
How much did I just add? Some.
Show us the bottle. You notice he always has a new bottle of Frank's hot sauce at the ready?
Probably a 1/4 cup if I had to guess.
A 1/4 cup of hot sauce. It's just vinegar. Oh, God. A 1/3 cup. He added, with the heavy whipping cream, he added a 1/3 cup of saturated fat, and he just added, by his guesstimate, a 1/4 cup of vinegar with a little bit of red pepper thrown in. And the Worcestershire sauce, already, I believe it's another vinegar-based sauce, right?
Now it is egg, heavy cream, Worcestershire sauce, and a little hot sauce.
Not a little, a 1/4 cup. He has his little Pam.
And all that glory.
Why don't you just lubricate it with all of the olive oil grease that's already in the pan? Just get a paper towel, soak up the grease from the pan, and rub that sucker down in your baking dish. You don't need to spray another fat in there. It's got so much fat, you can't even, it can't stick to anything.
Sufficiently browned.
It's not brown, it's gray.
Now how we're going to combine all this together is the real trick. What brand of hot sauce? Frank's Red Hot. I put that shit on
Oh
everything.
my God. Hold on. Did anybody see? How much was gone? You have
How
to
we're gonna
look.
Combine all this together is the real trick. What brand of hot sauce? Frank's Red.
Okay, you have to look in here at the white space. Like there's clear spaces all the way down to the label. There's stuff on the side of the glass which might confuse you into making you think, oh, he didn't put that much in there. There's a bunch of red hot sauce still in this bottle. There isn't. At least down to the label is gone when you actually look at it. Gosh, I wish I could zoom in on this. I think I could in OBS, maybe. No, wait, I'm in StreamYard.
Hot. I put that shit on everything.
Look, see? It goes below the label. Below the label is gone. I put that on everything. Yeah, we can tell, but look at this. It's somewhere down in here.
I'm going to go ahead and season the meat now. So I'm going to add to the meat directly some garlic powder.
Yeah, Sleeping Psychopathy and Steve C. Frank's is just buffalo sauce. It's not a hot sauce. And Steve C says Frank's is pretty tame. Yeah, it's not the heat that concerns me. It's the vinegar. That is so much vinegar going into your stomach. I've done shots of Tabasco. I've done shots of habanero Tabasco. It doesn't really bother me. What does bother you is after like the 5th shot of Tabasco, all that vinegar sits down in your stomach and makes you want to die. Like, that's the gross part. It's not the pepper. The pepper isn't a big deal at all.
And then I'm going to add salt and pepper to the meat.
Now, after he's done, quote unquote, browning the meat, he's now going to salt and pepper it. You know, any time prior to now would have been a better time than now. Literally any moment prior to right now would be better. The only good thing is that any moment after now is worse. What's happening? What was that sound? Was that him salting and peppering? That was like 20 minutes of seasoning.
Your time is glorious time. For you.
Fingers no grab phone. Make you casserole. This is a good angle. Oh, he's gonna switch the. He's gonna switch. There we go. Oh, he was salting it. You can see the salt all around, unless he's got meat just flopped out on the counter. Ew. What is he doing? That's pepper, I'm guessing. Is that he's grinding pepper, I guess? With a pepper grinder? There's only like 22 grinds. That wasn't that impressive. I will turn this meat over and put all of the pepper into the meat juice. Oh no, I'm scratching my head. It's contagious. He's still this.
I'm going to go ahead and
this
drain the
meat's-
liquid from this pot.
What are you going to drain it into? This meat still hasn't cooked. Like, what is he doing?
Or from this pan, rather.
Even if there wasn't, oh, he just threw it back in. Even if there wasn't liquid in there, it still wouldn't be browning because he's got it cooking on like medium low.
I'm going to drain the liquid from this.
Where are you draining the liquid? I mean, good, I guess. He's just pouring it down his sink, probably. Because that's what you should do. You should pour saturated fats, especially animal fats, into your sink, where once they cool down, they'll recoagulate into a solid and gum everything up. Cup of Sooth says, suing evil lunatic John Menard of Menard's Home Improvement, false imprisonment, assault, coercion, conspiracy against rights. Details on my Rumble channel. Guys, check out Cup of Sooth suing John Menard of Menard's Home Improvement.
Now, the tricky part, which I'm not sure how this is going to really work.
Best of luck to you, assuming
I'm
you're
not sure the
telling the
poll's
truth.
big enough for all this, but we're going to give it a shot.
Wait, what is this? What is MCT oil? He's got Tony's. Tony's is delicious. That's good. What's over here? This is some. This is a Walmart seasoning mix. It looks like. But what is this bulletproof MCT oil? I want to know. Let's see. Bulletproof MCT oil. Immune support supplement. It is ketone energy. My man does have a keto dish here, so I'm sure he's entering ketosis with this one. That's how the keto diet works, is you just eat as much saturated fat-filled meat as possible, and suddenly you're in ketosis, and your body thinks it's starving.
We're going to try to add all these things together in the same bowl. This is probably not going to go well, but we're going to give it a shot.
Warlock says MCT oil so you can have diarrhea bad enough to eject the 4 pounds of meat you stuffed down your gullet. Oh my gosh.
So bear with me as, I figure out how to put all these things together in one common bowl. This is going to be challenging.
It's impossible. You have more food than can fit in a 9x13 pan. You behemoth.
Bowl is probably going to overflow. Let's get started with this.
I have to go. I can't turn away. What are you doing? Why are you doing it this way? Why would you do it this way? What on earth is happening? You just scoop it into the 9x13 pans and then just pour half the eggs in each one. What are you doing? Why? Look at the grease. Ew, he even drained it. Notice he could have poured it into a strainer or a colander and gotten rid of significantly more grease. He could have poured it through a paper towel even. But he didn't. Oh, look at it.
No way to escape.
No way to escape. Even his food is trying to escape itself. Oh. Oh. Yeah, just scoop all that in there.
Okay. We still have veggies, though.
Oh!
We still have veggies.
Just pour them in the bowl.
So,
just put the bowl in the oven at this point. Make it a souffle. Why? I was joking. I was kidding. Why are you doing this in the egg bowl? This doesn't make sense. It's going to be so hard to get that into your casserole.
Cooking time with Uncivil is an adventure sometimes.
No, it's always an adventure. There's no sometimes about this. I've yet to see a mundane episode. I'm hooked. All right, guys. I gotta go. I gotta go. I have to go. I have to leave. We will revisit Cooking with Kurt. We will do that. We had 16 stuffed cannolis and 8 micropeens today, by the way, just so you know. Holy cats. I hate saying this. I may stream later today. I don't know. They said, I'm going to the doctor. I've been not feeling well the past week or so. Maybe a little longer. It's, I'm trying not to bog down the streams with it or anything, and I've been trying to keep it as something that doesn't interrupt the show, but it has made it's made doing some of the longer live streams a little bit more difficult. So that being said, getting everything checked out, and went to the doctor yesterday. That's where I was, and so now it's going and discussing some of the test results, hopefully, and seeing if there's anything I need to do other than getting a couple prescription meds. But that said, I would love to stream again later today, talk about not just Karen Reed, but other stuff. I hope you guys enjoyed the show today.
Hey, stop making fun of the amount of food he is making. At least he feeds the kids locked in his basement. The man in the mirror doesn't. Micropene for life. Van life, boys.
That's true. That's true. I've never fed kids in my life. All right, guys. We'll talk to you guys soon. Thanks for hanging out with me. As always, I hope you have a great day, and just watch for me on Twitter and on Locals for announcements of an upcoming live stream. Catch you guys soon. Peace. Peace. Play the It said the browser failed to play the clip. This one. It's not playing it. It's just not playing it at all. What about this one? My browser is done playing clips, apparently. It doesn't like it. So I'm just going to end without the outro song. Sorry about that, guys. Don't know what's up with that, but we'll figure it out. Peace. Peace. Go away. End the stream. An error occurred. Wait a moment and try again. I can't end the stream. End the stream. Let me go. It won't let me go. It says no. It says no. You can't end. You can't leave. Hold on.